everyone. Good afternoon, everyone, and thank you for making time. All of you, we really appreciate your being here. First and foremost, thank you for being here for this wonderful, terrific, long-planned event. We appreciate you for making time. First thing you may have noticed, I don't look like our Dean Christie at Shaw. Insert joke about whatever that matters, or well, it doesn't matter. Well, I should tell you, family events kept her from coming, and she said, among other things, I hate to miss it. I would have loved to celebrate the book launch with all of you. And she, of course, sends her regrets. I am Luis Fuentes Rohr, the Maurer Research Dean. I am here in her stead. I will only offer a few words, though I am thinking a few should be plenty. We're here to celebrate the launch of Dr. Asaf Lubin's book, The International Law of Intelligence, The World of Spycraft, and the Law of Nations, published by Oxford University Press. He's joined on the panel by Russell Buchan, a professor at the University of Reading, and Leah West, a professor at the Norman Patterson School of International Affairs at Carleton University. To both of you, thank you for making time to come to Bloomington and being part of this event. We really, really appreciate it. Thank you very much. I will only say this. I don't remember where I was when the astronauts first landed on the moon. I don't remember when the court decided Brown versus Board of Education. I don't remember when World War II ended. But I remember when I met Asaf Lubin in person. It was, he remembers. I know he remembers. It was September 13th, 2019 at 2:30 p.m. You came to Bloomington 12 days after that. You might be wondering, I know you are, how does he remember that? How in the world does he remember that moment with such specificity? It may be because he made such an indelible impression on me that his persona, that moment, became ingrained in my brain. That's one option. The other option may be because maybe, just maybe, I was chairing the appointments committee, and he was our first user of Zoom ever. In fact, he was our first candidate that year, 2019. And here's the thing, he was amazing. He really was. Zoom, however, was capital T, all caps, bold, italicized, underlined, terrible. And I remember walking out of the meeting thinking, I hope we never have to do that again. I was over the moon when he chose to come to Bloomington, he and Joao. And nothing he has done since that moment in 2019 has disabused me of that fact. As chair of that committee, I take all the credit. He's an amazing scholar, colleague, teacher, and friend. For me, I'll close with this. I can't wait to receive my signed copy of the book. And I can't wait to read it. If the introduction I read for the book is an indication, it's gonna be an amazing book. And as I said, I can't wait to read it. With that, I'm gonna step aside and let the experts do what they do best. And I will enjoy the discussion. Again, thank you all for being here, and the two of you, I can't thank you enough. And with that, Asaf, I'll give it to you. Thank you.
That's really kind, Luis. The funny thing is that what got us to start a bit late today is the fact that we struggled getting Zoom up. So clearly your premonition did not go as planned. I'm really honored and delighted to be here. In particular, I'm honored and delighted to be here because I brought I don't know if there's such a thing as academic best friends, but to the extent that there is such a thing, these two people represent my academic best friends. And I have a huge honor of getting to do the first real presentation of this book and its arguments with them. And so I'm really, really honored and excited to be here. I also will say This is a project that is 10 years in the making, 5 of which were spent as a doctoral student writing it, and 5 of it spent rewriting it as a faculty member. And it would be odd for a law school in particular, to embrace this kind of work. A work that is centered at the intersectionality of philosophy and morality and ethics and national security and international law, about something that is often not perceived as legal, perceived as at the edge of legal. And yet this is just a true token to the school and what the school is notorious for. Interdisciplinary work that pushes the boundaries of our understanding of what law and legal institutions are for. And this project is no exception. It's in that great tradition. All right, so let me walk you through the core arguments of this book. And we've orchestrated this song and dance a bit before coming here. And so I'll spend about 25 minutes giving you the core arguments of what this book tries to do. And then my colleagues will either agree or disagree with those core arguments. I know to you, they will disagree with some of those arguments. All right, so at the outset, yeah, if you can just click once, that will work, that's it. At the outset, this is me, okay? The fine, dashing gentleman on the front left with his leg crouched forward. That's me when I was 18 years old. That is slightly less than 20 years ago. Well, no, slightly more than 20 years ago. See, I'm getting older. It happened. It does happen. In the background is the Syrian side of the Golan Heights, now also taken by Israel. At the time, it was not. We are on the Israeli side of the Golan Heights. And what you're not seeing is what we're looking at. What we're looking at is a sea of satellite dishes. By that, I do mean a sea, endless, beyond the eyes can imagine. This is an intelligence base overlooking Syria. I served as an intelligence analyst in the Israeli intelligence community for 5 years. When I turned 18, many of my friends went to combat units. They became tank commanders and they worked at the Air Force. And many of them went through boot camp training. One of the first things they went through was a discussion about what it means to use firearm, rules of engagement, what it means to kill a person. And they were talked to about, basic ethical principles and the Geneva Convention. And so when we would come back from the weekends, it would be odd for me that no one in my intelligence course were giving us similar training. So I went to my commander, who's at the top right there. His name is Jonathan. And I asked him, Jonathan, why is it that no one's giving us training about what it means to spy on a person? What rules of engagement apply there? What is the ethics of spying? And I don't know if you've interacted with many Israelis in your lifetime, but when Israelis are unhappy, they use a lot of and sounds. and he used plenty of those and sounds. That you're kidding, right? Spying is about lying and cheating and deceiving. There's nothing ethical about spying. Spying is antithetical to ethics. And for the next 5 years of my career, I did not recall a single conversation we've had about ethics, about law, about privacy, about basic notions of what it means to do the work that we were doing. Instead, we accepted the cloak and dagger nature of the profession and sort of embraced the occupational therapy that comes with puzzle piecing. And we've puzzle pieced for 5 years. And then I went to law school, and one of the first courses I took at Hebrew University of Jerusalem was in international law. And anyone who's taken a public international law course before would know that one of the core features of that course is a syllabus that is built around various areas of state practice. So 1 week you learn about the law of the sea, another week you learn about the law of outer space, a third week you learn about the law of human rights. And so little old me expected that I was flipping through the pages to find a week where we devote ourselves to the second oldest profession. Alas, there was no such week about the international law of intelligence. So I went to my instructor at the time, and I asked her, why is it that we're not devoting a week to the international law of intelligence? And she said to me, with a lot of and sounds, you're kidding, right? International law is about the pursuit of justice where justice was once trampled. It's about good faith resolution of conflict. It is not about lying and cheating and deceiving. In fact, espionage is antithetical to international law. At that point, I wrote an LLM application. And the LLM application that I wrote to Yale Law School is the most grandiose most terrible LLM application every human has ever written. And I've given you some quotes from that terrible LLM application. Truly, the commodity of our generation, I said, is no longer gold, gunpowder, or barrels of oil. It is classified reports. This is why it is so daunting to learn, I wrote, that there exists a remarkable absence of scholarship, let alone well-established rules of international law on how intelligence is to be gathered, analyzed, or verified. And then I dared claim that international conventions, a UN authoritative monitoring body, some avant-garde interstate regional mechanism, or even an item on the ILC's agenda for future conclusions and commentary, all of those could help shed light on the legal penumbra of espionage, which threatens to unravel the delicate fabric of current world affairs. Now, this is terrible, not just because it is so bombastic and grandiose. It is terrible because it is flatly false. That is, there's been a ton of books that has been written on the subject of intelligence and international law, including on the bottom left, a book by Michael Reisman, the very same Michael Reisman who will read that LLM application. A book of his I did not care to read before writing my application. Later, Michael Reisman will make fun of me for this. Nonetheless, they accepted me to the LLM program and ultimately to my doctoral program under Michael Reisman's supervision. And I had changed my mind during the 5 years I spent at Yale Law School. I'm positioning myself on the argument that it's absolutely false, that there has not been any scholarship on the subject. I had now said that the scholarship that has been written has not persuaded me about what international law and intelligence do. And so it is my job today to try and suggest to you why that scholarship lacks and what I would propose in my scholarship to change or add to that. And we have to start with two great men. On the left, of course, is Hobbes. Hobbes believed that spying was, quote, a ray of light unto the human spirit. Hobbes believed, quote, that the nation state was a spider, and that its spies were its spider webs, feeding the great spider information. For Hobbes, the idea was that spying was always legal, no matter what the purpose or what the nature or against whom. He was building himself on others. Sun Tzu said, quote, spy, spy, and spy again. Hugo Grotius said that those leaders who choose not to spy, quote, do so out of their own loftiness of mind. The idea was that in the face of national security threat onto the nation, a nation has to spy time and again to prevent surprise attacks. That was the Hobbesian approach. Standing against him was, of course, Kant. Now, Kant believed in the perpetual peace, and the only way to achieve a perpetual peace, Kant believed, is to establish networks of trust between nations. And the most astonishing assault upon that trust, Kant believed, was spying, which he called a diabolical act. Others in his tradition had said that countries will forever forget club strokes on the head, but what they will never forget is the pinches of a needle, an attack on their ego. Nothing is greater an attack than spying on a country. Now, these two absolutist approaches end with the conclusion that spying is either always legal or always illegal. But those two absolutist schools, I think, are less relevant today. In fact, I would contend to you that there are two other schools which control the majority of the scholarship now. One is in that still absolutist camp, and the other is in a relativist camp. So let me start with the absolutist final camp, which is the extra-legalist camp. And for that, there will be one real, I don't know if nemesis is the right word, frenemy in today's presentation, and that is Professor John Radson, former general counsel to the CIA, who wrote this famous article in 2007, a part of which I'll quote in full. Mortals should not attempt to perform miracles. We cannot convert water into wine at weddings, turn lead into gold in a chemistry lab, or form a human being from a lump of clay. To accept reality, Afshin Radson tells us, is to abide by the laws of physics. And what are those laws? That espionage and international law cannot be reconciled in a complete synthesis. Perhaps we should leave it at that. No, he doesn't leave it at that. He goes on to say that those who wish to engage in research and scholarship on espionage and international law, nay, those who want to write a doctoral dissertation on the topic, and then they turn that into a book, do yourself a favor, move to other projects with grace. The introduction to my book says, I personally will take the grace but not the But it is reflective of a conception that still controls a huge part of our profession. That is military lawyers who will often tell me, what are you talking about? In fact, on this campus, a person shall be nameless, who teaches intelligence law at a different department, often told me that there's no reason to teach a course on international law of intelligence because there is no such thing. The problem I see with that viewpoint is that that viewpoint reflects a whole approach about certain spaces of national security being extra legal. Cicero once said that when the cannons roar, the muses fall silent. And we proved Cicero wrong when we built the Geneva Conventions. Now, by no stretch of the imagination is international humanitarian law an effective mechanism to regulate war, but it is a mechanism to regulate war. The idea that one cannot regulate particular national security spaces just because they're national security spaces represent an exceptionalism of the kind that fits Machiavelli, but not contemporary world order. And so I don't think the extra legalist camp is a persuasive camp, and indeed that legalist camp is not represented in the room today. But there is a camp that is represented in the room today, and that's the generalist account. And I think that account controls the majority of international law scholarship today. So let me try and map to you what most contemporary international lawyers think. And I will use a particular image to convey this. This comes to us from Fabienne Lafosse, a colonel in the French intelligence community, now a teacher at Sciences Po. He wrote a book in 2012 called all in French, called The International Law of Espionage, that I had to read page by page by using Google Translate because I don't speak French, including, with the help of João, translating this very slide into English. And so what he argues in that book is that there is no international law of intelligence as such. There are only general principles of international law that regulate all state conduct irrespective of its nature or focus or purpose, because all states' conduct is subject to these general principles. And perhaps one of the most fundamental of all principles is the principle of sovereignty. And so we can simply draw a double axis where we have the spying vector and the territorial vector. And all we do is we look at spies, spy ships, and spy aircrafts. And so long as they operate within the territorial sea or the territorial land or the national airspace, they violate international law because they engage in cross-territorial sovereignty violations in territory of a foreign land. Whereas if they operate in the global commons, such as the high seas, the international airspace, outer space, they will not violate international law because by definition, they will not violate anyone's sovereignty. The same can be done with other principles of international law, diplomatic protection, diplomatic and consular relations, for example. So if you spy on an embassy, you violate international law because the embassy is inviolable. If you spy from an embassy, you violate international law because you are not to use the embassy to collect intelligence against the national security of the host state, and so on and so forth. We're searching for general principles of law to regulate the conduct of spying as if it was any other kind of state conduct. Now, I don't find this generalist account persuasive at all, and I will give you 3 reasons why that is. And perhaps the most important comes from Hans Kelsen. Kelsen, in the General Theory of Law and State in 1945, wrote that a norm is considered to be legally valid on the condition that it belongs to a system of norms, to an order which on the whole is efficacious. What worried Kelsen is a legal order that is in complete detachment from reality. A legal order that is not descriptive is a legal order lacking validity. And the problem I see in international law time and again is that we tell ourselves a story of what international law is that does not match with what people see in reality. And so time and again, I have to defend the permissibility of international law to colleagues, despite the fact that international law, in my view, is a necessity for our order. And so the problem is rooted in the fact that we're telling a story of international law that lacks degree of descriptive account. This is true, of course, in espionage. We tell a story that spying is illegal if it violates sovereignty. There's only one thing. Every country spies, and every country spies from within the territory of other countries. In fact, it's the cheapest way to spy from the embassy of another nation, from your embassy in another nation. And so how do we balance the 2 facts that it is clearly done time and again, and yet in complete violation of this basic tenet. That will be my first concern with the generalist account. Of course, there's another concern. Generalist accounts are built on territorial line drawing but the conduct in question is territorially defined. Think about cyber espionage as an example. The assumption is always that the black line that Fabienne Lafosse drew is a clear line. But if we look closer into that line, it is far from clear. The African Union, for example, believe that cyber espionage is illegal because it violates the prohibition on the principle of sovereignty as applies as a rule in cyberspace. For the African Union, any unauthorized access by a state into the information, communication, and telecommunication infrastructure located on the territory of a foreign state is unlawful. The obligation does not include some kind of de minimis threshold of harmful effects below which an unauthorized access by a state into that infrastructure will be lawful. All of those are illegal. And yet Canada takes a very different view. Canada says that some cyber activities, such as cyber espionage, do not amount to a breach of territorial sovereignty and hence to a violation of international law. Indeed, how do we take a territorial line drawing and apply it in a space so anti-territorial like cyberspace? But it's not just about cyberspace. Think about Chinese spy balloons operating in a weird airspace somewhere between our national airspace of Montana and international airspace. See, part of, and outer space. Part of the problem is that in international law, we fail to have defined where the line is to be drawn between the territorial and the outer space areas. I would also argue to you that the same is true, without getting into weeds of it, of the exclusive economic zone, a zone within the seas that it somewhat carries away territorial waters while also carries certain high seas freedoms generated in the same kind of conflicts between the United States and China on easy surveillance. So against this backdrop, I suggest to you that there is a different way to think about the international law of intelligence, not the one that the generalists have adopted. And I draw my attention to a different body of scholarship altogether, one that is not rooted in law. Rather, it is rooted in moral philosophy and ethics. A group of scholars in intelligence studies, many of them themselves former intelligence officers, as well as philosophers like Cecile Fabre from the University of Oxford, in the bottom left of your screen, Spying Through a Glass Darkly, have now built a body of scholarship that tries to suggest that there exists a set of moral deontological principles that guide the collection of intelligence on the international stage. And they have built a framework around that regulation. And that framework is quite familiar to most academics working in this space because it builds on the just war theory model. They call it just intelligence theory. And the argument is quite simple. In the same way that we can think about jus ad bellum, jus in bello, and jus post bellum, about the law regulating the launching of war, the law during war, and the law after war, so can we think about the international law of intelligence, a regulation at three distinct temporal stages: before, during, and after. But you see, the problem is that the just war theory needed a secular translation. From its original Christian roots, it needed the work of liberal lawyers to translate into the language of the UN Charter and Geneva Conventions that we all teach today in public international law. Who will do the work of translating the moral philosophy of just intelligence theory into the language of international law? In the book, I offer my first attempt at that act of translation. And so I propose, as the European Court of Human Rights had said in the famous case of Zakharov v. Russia, the review and supervision of secret surveillance measures may come into play at three stages: when the surveillance is first ordered, while it is being carried out, or after it has been terminated: before, during, and after. And I coined these jus ad explorationem, jus in explorationem, jus post explorationem. Now, I note to you that the International Court of Justice in the Southwest Africa case said that a court of law can take account of moral principles only insofar as these are given sufficient expression in legal form. And so what I do in the book is try to give them legal form. And I build a legal framework. The jus ad explorationem deals with macro level necessity, proportionality, and efficacy of an intelligence operation. The jus in exploratione deal with a micro level necessity, proportionality, and efficacy of fleet intelligence gathering. I suggest that these can be found within customary international law. And I further suggest that at times these customary rules get codified or rejected by particular treaties that either codify the liberty into a binding claim right or completely reject it, so it exists as a no right in particular circumstances. I'll make this argument in the last part of my presentation to you today, but I want to say a word about sources. So as I noted to you, I suggest that this framework, the international law of intelligence, is embodied in customary international law. In essence, I suggest that unlike the generalist, there exists an international law of espionage as such that regulates intelligence as a specialized conduct tied to its historical roots, to its long laundry list of acronyms, to its long tradition of practice and best standards adopted by the profession. The problem with that argument, argue those who detract my position, is that custom cannot evolve from secret practice. That if intelligence agencies conduct their conduct in secret, then that secrecy denies the ability of an iterative exchange of rejection and adoption that could result in the formation of custom. I have opinions of that, but I reserve them from now. My book, I builds a three-part argument because I've had these exchanges so many times. So those in the international community who say to me that custom cannot form, I suggest then that the same ILI, the same principle I just read to you, do not come to us from Article 38(1)(b) of the ICJ statute, but rather from Article 38(1)(c), that they are themselves general principles of law, the general principles of proportionality, necessity, and efficacy, principles that have in the past been recognized by international courts and tribunals. And I know to you that that is why I chose such a rudimentary framework, because at the very least, I can defend the argument that these general principles exist. The problem, of course, is that for international lawyers, 38(1)(c) is a black hole. No one really understands what 38(1)(c) as a source of law even is, or how it applies as a co-equal source of law. We debate in particular, not just the identification of particular general principles, but their scope of application alongside treaties and customs. So to that detractor who disagrees with me on this point, I come to my final argument in the book, which is perhaps the most controversial. For you see, I am the result of the New Haven School of International Law. That School of International Law rejects by design the rigidity of formalism and embraces shades of legal nuance. McDougall, Lasswell, and later Reisman all adopted the argument that formalism by itself cannot account for an understanding of complex policy environments, in particular not the kind that espionage and intelligence generates. If I am to just play on the playing field of those European positivist formalists, I will inevitably play with one hand behind my back, tied. The reality is that the complex world of intelligence, the wilderness of mirrors of espionage, is by design resistant of exactly this kind of formal codified frameworks of public law. And they require us to adopt a more complex understanding of what law's function is, what intelligence function is. So I will end my presentation today by just giving you a few examples of how my framework applies. In the use ad explorationem context, I'll just give two brief stories. The first is this absurdity coming to us from one Benjamin Netanyahu in 2018. Benjamin Netanyahu in 2018 goes on the stage in classic Netanyahu style, puts black robes behind boards of empty CDs and even emptier cabinet folder and paper holders. There's nothing in there, but it's a show that is meant to represent the Mossad's activity a month earlier of collecting trove of information from the Tehran bunkers, where allegedly information about the secret nuclear program of the Iranians was held. The information is then shared with the P5+1, the permanent members of the United Nations Security Council plus Germany, as well as the International Atomic Energy Agency. If the generalists are true in their belief that there exists in international law a prohibition of precisely the kind of territorial espionage that the Israelis engage in this operation, all of those countries, and in particular the United Nations IAEA, would have rejected the intelligence offhand. They would not want to find themselves complicit in an international law violation. But far from rejecting it, they accepted it with glee, read everything, and wrote reports on the basis of it, suggesting to you that perhaps the function of intelligence in public order is more important than the general principle of sovereignty. That the idea that we are to protect international peace and stability against the violator of the Non-Proliferation Treaty might be more profound than just a fight over the rigidity of the principle of sovereignty implied in a purest sense. Another one of my favorite stories of all times, and this is truly a spy saga for the ages, has to do with Australia and East Timor. And it's one of those stories that I teach my students all the time because it is just too unbelievable to be accurate, except life resists even the most craziest of stories. East Timor exists in a tiny island speck north of Australia, there in the orange circle. And for the longest part, it was subject to Portuguese control under colonialist rule. In the 1970s, it finally gains independence, and that lasts 7 days, taken over by Indonesia. For another 20 years, it is subject to Indonesian control. In the early 2000s, they finally gain independence, and they are so excited. Finally, they can build presidential palaces that can commemorate their newfound sovereignty. Just that there is no such architects and big shot aid workers who can come and build this magnificent architectural feat. So they reach out to the Australians and say, Australia, if you don't mind, can you help us build this kind of building? And I don't do Australian accents very well, but I'm sure they said, sure thing, mate. And then proceeded to place 2 of their intelligence officers into the construction team. And with every wall that was built, they placed recording pods into the walls. You can already ask yourself right there and there, why? What is the national security threat that East Timor poses to Australia? Of course, there is none, but there is gas in the East Timorese Sea. And the Australians know that there is gas in the East Timorese Sea, and they are worried that East Timors will find it first. In 2006, of course, East Timor does find that gas, and they're excited again. They can have their first natural resource to exploit. There's only one tiny problem. You see, they don't have the big shot boats that can extract that gas from the bottom of the ocean. What will they do? Well, they reach out to Australia again, and they say, if you don't mind, let's negotiate a deal whereby you'll get a small percentage, we'll get the rest. It will be a win-win situation. The Australians say, sure thing, mate, but if you don't mind, let's negotiate this deal in your newly built presidential palace. With every day of negotiations, the Australians leave the room and listen in to better their negotiation position for the next day. So much so that by the end of 3 weeks, not only did East Timor commit to not search for any more gas for the next 50 years, but they also commit to giving 60% of that gas to Australia. In 2011, a Snowden-like fella comes out of the Australian intelligence community and says, enough is enough, I have to come clean. East Timor, we spied on you during treaty negotiations. The East Timorese get enraged. Friends don't spy on friends, after all. They sue. Under the treaty, there was a clause that said that any dispute about the interpretation of the treaty goes to the Permanent Court of Arbitration in The Hague. But there is one problem. They don't have big shot lawyers that can represent them in The Hague. So they turn to Australia once more, and they hire an Australian lawyer to represent them. At this moment, the Australians are like, this is too easy. They begin spying on the lawyer. Not only do they spy on the lawyer, a day before proceedings are supposed to commence, they get a court order for national security reason to seize all the documents that the lawyer was prepared to use in his testimony before the court, including the passport of witness K, who was supposed to testify about what he had done. These Timorese get enraged. How dare you spy on our lawyer? We'll sue you again, this time in the International Court of Justice in The Hague. And for the first time in East Timor's very short existence, they realize they can outsource elsewhere. They get a British lawyer to represent them, who brings the court to issue a provisional measure that indicates that maybe, just maybe, that spying was illegal because it violated attorney-client privilege. It was at that moment that the Americans intervened. But you see, we spy on lawyers and during treaty negotiations for generations. The last thing we want is an ICJ decision or a PCA decision that makes any of this illegal. So we tell the Australians, you pay as much money as you need to pay to get both of these cases out the door. Takes 3 more years of negotiations. The treaty gets cut out. A new treaty is signed, returning all the rights for the gas back to the East Timorese, and the 2 cases disappear. You want to know how I know all these details? Not all of them are super public, because Michael Reisman was one of the 3 arbitrators in the Permanent Court of Arbitration case, and he shared some of these details with me as I was writing this book. The reason I tell this story a lot is because for a generalist, what Australia did was illegal because it violated sovereignty. But I don't think that gets into the heart of what made Australia's actions illegal in this case. See, my proposal isn't about enhancing more spying in the world. Far from it. My proposal is to regulate intelligence as such by understanding what intelligence functions is and what it is not, to understand also how the power may be abused. One such way is to use it not for the purpose for which it was intended. Spying on East Timor in this case was not to advance national security or international security, is to steal a natural resource for a poor developing country, post-colonial. In that circumstances, there is no meaningful justification for that spying, and that spying is illegal because it violates the use ad explorationem. It is unnecessary, let alone its disproportionate effects. I'll end with one final example in the use in exploratione context. This is the law governing the means and targets in the conduct of spying. And that is a story that comes to us from the conduct of the CIA in Pakistan. In the lead up for trying to find Osama bin Laden, the CIA placed its men into a vaccination program for the polio within Pakistan. The weird notion was that somehow through vaccinating children in Pakistan, we will collect enough blood samples and addresses to find where Osama bin Laden's children were located, and thereby to find where Osama bin Laden was. Who knows whether any of his children ever were vaccinated for the polio? One thing is certain, that program was not successful. And indeed, when it was revealed that the CIA was infiltrating that kind of vaccination program, 60% of families in Pakistan refused to vaccinate their children, saying it was a Western hoax. This led to 14 medical school deans writing a letter to then President Obama demanding that the CIA will never again engage in non-official covers involving vaccination programs. The next year, the CIA publicly denounced the program and promised to never do it again. I don't know if that is true today, but what I do know is that that program again represents a set of principles that should guide the way we think about intelligence. Not general rules like sovereignty and diplomatic protection and human rights, particularized rules about why this operation is clearly defunct, morally and legally, because its chances of success was extremely short, and its disproportionate effects were clearly high. The operation should not have been launched because it was a bad operation. And that kind of simplicity guides every single intelligence agency in the world today. Whether or not they follow those principles is a different matter. But the idea that there is enough state practice and opinion jurists to support the notion that these principles guide this activity is true. Final slide, I'll just end with this. The book has an appendix, an annex, which is the syllabus that Matthew Waxman and I co-authored for a course that we taught at Columbia Law School in the fall of 2023. It is part of a broader educational agenda about the international law of intelligence, so that never again a student will be told that international law and intelligence have nothing to do with one another, and therefore they should not be part of a curriculum. Which is why, for the last 2 years, I've taught this course here at Indiana University. I plan to continue to teach it for many more years to come. That's the short of what this book is all about. So what we said we'll do from here is that my 2 colleagues will each take 15 or so minutes to stick stabs at all the arguments you just heard from me.
Okay, I think I'm starting. Thanks very much, Asaf, and thanks to the university for the hospitality since I've been here. Last night I went to watch the final of the Masters golf. I'm a golf fan, and Justin Rose was supposed to win, who's from my hometown. He didn't, but I had a good opportunity to sit and speak with a couple of your students whilst watching the golf, and the way they talked about the university so enthusiastically, so generously. It was very clear to me that this is a very inspiring place to learn, to work, and to live. So I'm really happy to be here. And more than that, I'm very happy to help Asaf celebrate the launch of his book. I've known Asaf for a long time, both professionally and personally, and he's had a huge impact in international law generally, but in particular in the field of intelligence studies, the application of international law to the work of the intelligence community. So I'm very honored to be here. I think perhaps one of the reasons that I was invited to be here is because there are some real points of disagreement in the way Asaf and I see the role of international law in regulating espionage, and I will move on to those very shortly. But I do want to echo those points of agreement between us, because they really are very, very important. Because as Asaf said, historically, if you looked at the international legal literature, first of all, there was very little that's been written on it. Many of those books that Asaf put up on the board, on the PowerPoint slide there, have been published very recently, post-Snowden, really. Before that, I think there's a handful of books, maybe 3-4 books that had ever been written on international law and espionage, which, as the second world's oldest profession, there's a clear paradox there. Compare that with how many books that have been written on IHL or international human rights law. But of that literature that had been written, it was almost unanimous amongst those scholars that international law did not apply to espionage, as I've explained. And I always like to roll out a few of those quotes, just because I really do think they exemplify the point that I want to make, and that Asaf made himself. One scholar says that international law is silent on espionage. One international lawyer said that international law is agnostic to espionage. One other said espionage operates in a legal black hole. Another said a legal netherworld. And my favorite was not written, not published, but said to me in person, was by the late, great Professor Yoram Dinstein, who, when I told him I was researching on international and espionage, told me these are two things. They are ships that pass in the night, never to meet, which I thought was very strange, very close. In my work, I push back on that. In Asaf's work, he pushes back on that. And that might seem quite basic, that international law applies. International law is built upon the sovereign equality of states. Espionage is one state stealing something that another state wants to keep secret. International law says nothing about this activity. To me, seems perverse. But I think collectively we are in agreement on that, and we've worked very hard, and often under very difficult conditions, to the intelligence communities to make that point. So that's where we're in agreement. It's important agreement, and it should not be forgotten, bearing in mind what I'm about to say now. So as I've very articulately explained, he envisages this lex specialis, which is international law jargon for a specialized legal framework that applies to espionage. It's predicated on tripartite principles of necessity, proportionality, and efficacy. I'll return to what they mean, what I think they mean, or as I perhaps thinks they mean, in a moment. But I was discussing this a couple of days ago. I was at another conference. I mean, I think fundamentally many of the problems that we have in international law are a sources-based problem, because of the decentralized nature of the international political and legal order. So in light of that, unsurprisingly, I want to address some of the two main legal bases. The third one, I think, as I've said, is the New Haven World Public Order stuff. I don't know what that is. I'm not going to go anywhere near that. I'm going to stick to the law. So I will look first at Professor Lubin's customary claim, and then move on to the issue around general principles. It's really a question to, as of course, I'm sure you set this out in the book, but when it comes to the identification of customary international law, for the non-international laws in the room, custom is basically a source of law where, if we are all the states in the world, if we all start doing something sufficiently frequently, and we start doing it because we believe it's required by law, not political nicety or social or whatever, by law, then over time it can become, could transform from a norm into a binding rule. Now, you must have loads of questions about how many states, at what point in time, what if they disagree, what if one disagrees, what's this idea of a belief of law? We call it opinio juris. I'll use that shorthand, so forgive me, but it's this mental element. How on earth do you prove that on behalf of the state? So you need a theory of custom, And there are different theories. There's a very good article on this by Stefan Tolman in the European Journal of International Law, where he looks just at the jurisprudence of the ICJ, the International Court of Justice. That's without looking at all the other international tribunals and states and everything else. Just at the ICJ, the World Court, which you think would be incredibly clear and consistent on how it identifies this main source of international law. The title of his article is Induction, Deduction, or Assertion. And the conclusion of the article is all of them. And what he means by that is that the ICJ flips and flops between different methodologies. One is induction, which is that states induce the existence of custom through their practice and their opinio juris. Deduction is that we have these big meta-legal principles, sovereignty, non-intervention, and you deduce other principles from smaller principles, narrow principles from those wider ones. And finally, assertion, which unfortunately the ICJ does not. It just says this is custom and doesn't give you any evidence for why that is the case at all. Now, I think Asaf takes an inductive approach, which then raises the question of, well, what theory of induction do you have? Because there are many different views. I mean, the traditional view is that you need widespread, representative, and consistent state practice in order for custom to form, in addition to the opinio juris. That's not the only view. Some scholars, indeed some courts, sought to lower that threshold. So there's a famous article by Frederick Curtis in the American Journal of International Law that says custom on a sliding scale. If you have more state practice, you need less opinio juris, and more than one, less of the other. And I'm wondering where you come out, and do you articulate a theory of custom, and what does that look like? I think that is a really important foundational question. As I say, I'm pretty sure you're an inductive person, so let's look at state practice and opinio juris. You've alluded to this in your slides already. So you're going to need this decent amount of state practice in order for custom to form. But it needs to be, I'd say, the traditional approach is that you need widespread, representative, and consistent state practice. Does your espionage meet that threshold? Quantitatively, does it do that? Representative is about the world, so it's not just a couple of powerful spine states, representative of the world. Do states do this? Consistent, widespread, high threshold. But it's not just about the quantity, it's about the quality of the state practice. And there are certain types of, well, I won't even call them state practice, I call it state conduct, that are not methodologically relevant to the identification of customary international law. The big one is secret state practice. Why? Because if a state is engaging in secret state conduct that it does not disclose to the international community, how can all of you guys react to that? Custom forms on the basis of this iterative process of claim and counterclaims between states. If it's not publicized, there can be no community back and forth and discussion. Why is this relevant to this discussion? Espionage is inherently secretive in nature. So how it can contribute towards that column, that state practice column, and support a customary international law in favor of it. Then we can move to the opinio juris side, and are states saying that this particular thing is lawful under international law? I don't think so. First of all, many states, when they're subject to espionage, don't even know that it happened. Espionage is its most effective when it is non-detectable, when it's not detected. So many states don't even have the opportunity to react to this practice. Even if they do find that they've been a victim of espionage through Snowden or the like, I'm not aware. There are examples, but I'm not aware of states protesting against that particular activity or accepting that particular activity. The reality is that there's this moniker of neither confirm nor deny. They usually do nothing. Whereas I think if you're looking at looking to identify opinio juris, what you'd have is other states coming out and going, yep, you've done this, it's either it's on this side because it's proportionate and therefore it's lawful, but it's unfriendly, or we think it's unlawful because it's disproportionate, and having that conversation. Really, they do nothing. And again, if you're trying to build a binding rule that will hold states either as acting lawfully or unlawfully, all of this feels very kind of building too much, is building on sand in essence. Now, in recent years, we have had states come out and protest certain things. The spy balloon instance is a good one. The SolarWinds incident is another. But the language coming out of states is, again, is very political. it's referring it to as reckless, or perhaps with Snowden. Germany, Angela Merkel said, friends don't spy on friends. What does that mean for international law? I think it means very little. And remember, the onus is on people like Asaf, who's making the claim this is custom, to demonstrate these elements. That's the burden on him, not on me. And I'm just wondering where that. So Asaf's used the concept of a descriptive account, because what Asaf's going to say to me is that I'm living on cloud cuckoo land. Of course they spy. They're spying all the time. We know this. Everybody knows this. Come back down to earth. Describe reality. Well, my response is, well, I want a descriptive legal account from you on that. I know that you do that. I get excited. I don't know why. And let's then move to the second basis, which is general principles. Very interesting. I'm really interested to discuss that, because this is a blind spot for international lawyers. And so, grappling with that in the context of a topic like espionage is going to be fantastic. Why is it a blind spot? Well, because it's just pretty tricky, really. What general principle is really when the international looks down and says that all these states are doing something as a matter of national law, and therefore we need to extract it from them and transpose it into the international legal system. So what Asaf needs to do is to look to all of these states and identify that the principles of necessity, proportionality, and efficacy, his tripartite framework, is practiced as a matter of law in those national systems. Therefore, it's appropriate to extract them out. That's a heavy lift. I've not done that. My question to Asaf, has he looked at the common law tradition? Has he looked at the civil law tradition? Has he looked at the Chinese law? Has he looked at the Islamic law? And do they do that? I'm fascinated to know, but I imagine that was a lot of hard work. Let's just say that you can extract them out. And let's just say ontologically, there are these things called general principles. And they're necessity, proportionality, and efficacy. My next question is, okay, tell me what they mean. I'm dying to know what proportionality means. Proportionality is pretty interesting because it comes from what? I work in the area of international human rights law. Proportionality is critical there. I work on what we call the jus ad bellum, which is basically UN Charter stuff. It comes up there in the context of self-defense, as we're seeing in Israel, Gaza at the moment. I work on international humanitarian law. Proportionality is also super important there. As I know, counter-specialist doctrine very well. Proportionality comes up there. Proportionality means different things in all of those frameworks. Now we have it in general principles, restricting or perhaps permitting, applying to the intelligence community. To tell me what it means. You align it with this idea of moral principles, and of course, my morality is very different from Shaul and Leah's morality. And let's just give you an example. It really bothered me when the US administration came out and said, solar winds, it was reckless. And they didn't use international legal language, but they just couldn't. So we'll just stick with that. They called it reckless. I thought to myself, well, a few years ago, Echelon and Prism, as it happens, solar winds was pretty discriminatory. It was pretty discriminatory. If you look at the tech, the way it could be controlled, it had human oversight. It only got into those systems that had some kind of national security value. It was pretty. Echelon wasn't. I think Charles used the dragnet. It was a dragnet. It was reflecting everything. So as if you think Echelon and Prism is proportionate, SolarWinds is not. I'd be interested to hear a lot about that. And then, oh gosh, I've got so much to say. Where do I stop? I have to just choose my last one. Well, let's just stick with. I think this is quite an important point, because, as I said to Asaf the other day, the reason I like espionage is because it's just a lens into international law. I mean, it just reveals all of these systemic problems. Sources is the big one, but it's about regime interaction. There are all these different issues. And general principles. So let's say there are, your claims is general principles, the necessity of proportionality, general principles under Article 38(1)(c) of the ICJ statute. And you say that they act as standard clarifiers, sorry, rather than gap fillers. So I think what you mean by that is that they are interpretive tools that can help us better understand other areas of international law. So it's a bit like military necessity in humanity in the context of international humanitarian law. Military necessity and humanity in IHL are not freestanding rules. You cannot breach the principle of humanity. You cannot breach the principle of military necessity. They are normative forces on the law. So when you come across a provision that says you cannot directly target civilians unless they directly participate in hostilities, what does direct participation mean in the context of Gaza at the moment? Well, the way you interpret that legal rule is by going to those kind of foundational principles and saying, well, does this interpretation balance out humanity and necessity? And that will get me to where I want to go. Is that the way that you're when you say they're standard clarifiers and they're not gap fillers, is that the kind of way that you're using these principles? Because if you are, then perhaps what you're doing is looking at extant rules, say sovereignty, and then using those those meta principles, those normative principles, to help you interpret how sovereignty applies in practice. So the question there, is it really a lex specialis framework you're constructing, or is it not? Something to take spying on an embassy would prima facie run into breach in a number of the violability provisions of an embassy. They have inviolability of premises, of documents, of archives, and whole host of other things. Is what you're doing when you apply the Vienna Convention on Diplomatic Relations saying, hang on, those rules look a bit shrill, and we'll interpret them through the lens of necessity and proportionality. So if it's a limited espionage activity, if it doesn't have these long-term effects, if it's very strategic, it's proportionate, it's necessary, and it gets the job done, it's effective, ticks that principle of efficacy, then there isn't a breach of the Vienna Convention on Diplomatic Relations. So I think if that's what you're doing, then you're still sticking within the existing rules, and it's not so much a lex specialis framework. And I will finish on this point, which is about lex specialis frameworks. Asaf's book is called International Law of Intelligence, which does point towards this direction of there being a specialized framework. We have a law of armed conflict. We have a law of the sea. We have a law of outer space. And they are these specialized regimes, and they do particular types of things. Sometimes they derogate from the general law. So again, we were talking about this last week. The Outer Space Treaty has a whole regime on attribution, which is completely different from the general rules on attribution. So states can do that. If they want to create specialized regimes, they consent to it, which is the foundation of international law, then they can do that. Asaf, I think, sees us having arrived in that position already. I'm still on the side of we have an international law on intelligence, but the reason I like Asaf's work is because, again, I still see is more aligned on this point. I do think that's where the law is heading. I do think if we're back here in 20 years' time still talking about international law and espionage, the states will have come out from the cold, and states will have formulated this international law of intelligence. But fundamentally, I don't think we're there yet, and I think it's going to be a difficult road to travel, whereas I think you think that we are there.
Now you understand why I invited Russell here.
So before I start, I'm just going to double down on the sources issue, because I did just try to do an empirical study of state practice for cyber operations that below the use of force. So stuff like espionage, data manipulation, or whatever. I looked at 17 countries. I had students with specialized language skills. We were going to look at statements, at legislation, at judicial decisions, at their public statements, right? Knowing that this is a field that happens below the radar, but I was convinced I would find something. I got nowhere. I have lots of money to do a project that I'm reconceptualizing, that I've invited both of you to, but it is not that, because I simply could not do it. It is very hard work to find empirical evidence of state practice of espionage, and one in the cyber context. And you mentioned this, they usually do nothing. Well, now states, if they can attribute to a state, will say bad state, but try to get them to explain why it was bad, right? There is no invocation of international law. So you don't get the opinion juris. You get the normative that was bad without the why in international law it was bad. And I stared at the head legal for Global Affairs Canada a couple of months ago and said, the next time you attribute, can you tell me why they broke the law or why what they did was bad? Please, because we're never going to advance the law if we just say bad state. He didn't seem convinced. So I don't really have a dog in the camp fight. Because I'm a national security lawyer and I typically look at national security law domestically, how it regulates our state conduct or the conduct of our state actors. And in Canada, as in most states, our domestic law, however, needs to be interpreted in light of international law. Our approach is, unless it is very clearly articulated that international law does not apply, the presumption is that our legislation is consistent with international law. So I've been a legal advisor for our spies. I've also been an operator. I was one of those 10 commanders. They come to you and say, can I do this? And I look at the treaty and I have to interpret that treaty in light of international law. Now try to do that in light of this conversation. It's not easy. And oftentimes completely unclear. And so my dog in this fight is settling on one of these two. For a long time, there was, and until very recently, even the Canadian Federal Court, who issues warrants to our security services, said spying is not purely legal or illegal, or nothing in international law regulates spying. These are things that our court has said until very, very recently. They recently started taking the generalist approach that Russell ascribes to, and that is at least helpful when you're a legal advisor, because you can say, okay, at least I know where we're starting from. But it doesn't get you very far when you're trying to advise a spy agency where you're like, breach of sovereignty, right? Like breach of sovereignty, right? Like you don't get very far. So what did our Canada did was just legislate around it and say international law does not govern this activity. So less helpful, right? So now you have a gap. So then what are the principles that govern that conduct aside from the limited text that you have in the legislation? So I will say that at this point, the generalist approach is the most useful, but it's also, I have a hard time reconciling that law with the practice of states, because Canada, a state that's not known for spying on people, just said, well, we'll just not make international law apply in certain contexts, right? So the law itself is not consistent with state practice in that way. But until now, there were no alternatives. And so Asaf is presenting us with an alternative. And that to me is really exciting. And I commend you for it. I also commend you for having the courage to do that, because it's a hard thing to put yourself on the line and approach and put something out that is so controversial, even amongst best friends. And I'll say that I also teach national security ethics. I teach national security. So that second slide with all the books about national security ethics, I teach that separate and apart from national security law. Because these two things do not actually overlap as it currently exists. They are not coexistent. They are a little bit, and more so now, because, and I'll come back to that as to why, but they typically don't overlap. One is the realm of professional ethics. Intelligence is the second oldest profession. Intelligence practitioners view themselves as a profession with a code of ethics and that they ascribe to. And so this idea that there is principles that have long guided the profession is true, and it's becoming more professionalized in recent years, where you actually can see texts that lay out the professional ethics of intelligence collection and analysis. But the one thing I'll say, and one of the things why I think what you're saying is very courageous, is because operators and those who advise them are afraid of law. to them, the law is only a constraint, right? They much prefer operating in a sea of strategic and sometimes not strategic ambiguity, right? It gives, they feel, and I say this especially in the armed forces context, they see law as only constraining rather than permissive in the context of intelligence. But I think there's two problems to, at least as a legal advisor, I always have two problems to this ambiguity that exists. And they cut either direction. Either in crisis or emergencies, if there's no hard and fast line, states will run right over it and engage in activities that are clearly beyond the pale of conventional norms, if not law. But also, in times of increased scrutiny or scandal, which we've seen a lot for our intelligence communities in all three of our countries over the last year, they'll constrain themselves further. They'll place not only one arm, but two arms tied behind my back, which is who I dedicated my book to, is those who fight with two arms tied behind their back, because they can't get political will to engage in things where there is not clear legal authority to do something. Where you can't say to the director, this is definitely clearly legal, we can do this. They will not engage in that practice where there is a lack of legal certainty because of the fear of heightened scrutiny. And so sometimes you get running over the line and trampling, the rights of others, but also you can get this constrained reaction where states may not take action in their best national interests because of fear of going over the line. And so I always think of it as a sandbox. You need to know where the perimeters of your sandbox are. And when you work in the intelligence world, you go right up to the edge of your sandbox, right? Because of what you need to do in order to defend your national interests, but you don't cross. And I find that ambiguity either takes away those edges or it keeps people too much to the center of their sandbox. Another thing you didn't mention, I don't think in here, but in the chapter or the introductory, you talk about this concept of lex imperfecta, which is having law, but it is basically a fig leaf of law. So the law itself doesn't really do a whole lot. It has no teeth, which is, I think, what you could say, or many people would say, to the generalist approach to international law. In constitutional law, there's a similar concept put forward by David Deisenhouse, who funnily enough read my SJD application, where I did not know he had that theory, and I talked about holes in law, and fortunately he was gracious and didn't point out that he had a theory on such things. To be a young student. So he has a theory on gray holes, and essentially there's black holes and gray holes, and black holes in law, there is no law, which is how people used to conceive of intelligence and international law. Simply, it was extra legal. It was not adjudicated by international law. But I think now, especially in the digital era, applying the generalist approach gives us some gray holes in law. So there appears to be law, but when you push on it, it doesn't really give us a whole lot. And trying to fill those gray holes, I think, is part of the project of law. That's David Deisenhouse's approach. You're contributing to that project of law. And I think that's very helpful. The last thing I'll say is that going back to the source problem, I think that problem will get easier with time. Not in all states, certainly, but because we are in a new era in liberal democracies, I hope this country stays in it, but at least generally, we're in a new era of liberal democracies where, and Omand in his book that you mentioned, talks about this idea of a social compact theory of intelligence or model. So we now conceive of intelligence agencies working in our interest, right? They work for us. right? They are responsible to our elected officials who give them their intelligence priorities, their marching orders, gives them their regulations and authorities of what they're allowed to do. And they do it in our names. Yes. And so because of that, we have seen a growth in the regulation of national security and intelligence, of the national security and intelligence agencies, review bodies. We've seen the judicialization of intelligence, so more and more action having to be blessed by a judge in advance, which in some instances leads to judicial decisions on that and legal reasoning, and opportunities for administrative review as well. So I think we're going to see more in terms of sources and methods that will allow you to buttress your theory going forward. But like I said, in many instances, this is still very much piecemeal. But I think I don't think that change or that model is going to be anytime soon.
Well, first of all, if you can join me in just thanking these two. I don't want to take too much time. Let's just say two things at the outset of this. Needless to say that we will be continuing. In fact, we're taking the song and dance tomorrow to a student-facing event at Hamilton Liberal School. So rest assured, we will continue the good fight. But I will just say to you at the outset that what you just witnessed is demonstration of why this field is a field. And reviewer 2 of this book does not believe this is a field. And it took many different back and forths with reviewer 2 to convince, but assume, well, I won't say it's a him, but I'm gonna assume that, but maybe not, who knows? But that it's a field. And I think what you saw today is the demonstration of the legal debate surrounding these issues and how profoundly intimate and important they are, but also just how much the analysis surrounding them is profoundly important for the law in general. And I think that what is often missed, and why this is more than anything a pedagogical agenda, is that the reason why we can't agree, the reason why we're still stuck in camps, is because not enough people are spending their intellectual time thinking about how to think this more deeply and more profoundly. And I think that is something we'll get full agreement across this table on. And why I will forever in my career continue to espouse this kind of agenda forward. So that's the first point. I have many different responses to my colleagues, and we'll talk this through over dinner. For now, I'll just say that I wrote this book because when I served in the intelligence community, I had done things that I don't think were illegal, but I certainly think today were icky. And I was provided no mental therapy, let alone concrete discussions about them. This book writing was my mental therapy surrounding. Some of them I mentioned in the conclusion, others I don't. But the reason why I struggle with the generalist account more than anything has to do with what Leah was saying about operationalization. I lacked, and even post my book continue to lack, operational understanding of whether or not some of the conduct that was involved in crossed the line. And as with all great moral questions, this is likely one that I will carry to the last of my days. But it is profoundly why the topic is forever going to be a part of my academic existence. And so with that, I'll stop. You take Danishes, there's plenty of them. I think we're coming to that. If there's 10 minutes, I don't know, Luis, you're the boss of me, really. You literally hired me. You made a big deal. But I know, for example, so let me just say, I know for a few of you have to go. So if you have to go, please don't stay. You don't have to go and you want to talk to us for another, because we have to leave at 6 definitively, but we have those final 10 minutes. If you want to ask anything or talk with either we're happy to do it. Please, yeah.
Well, first of all, congratulations on this book. It's so wonderful to see that you're finished, and if you have a pre-order link to share.
Coming out soon, in a month.
Love to get it. And I guess, a compliment to you. At least for me, I feel convinced that this is a field that's needed, and I really much see it, I guess, from my own perspective as a law and society scholar, really informing understandings around how, law in action, right? So I guess, my question for you is the most of your critique around the generalist approach about the substance, how they're defining what the law is, right? Or, and I guess I had a fundamental question for you about what law is too, and about the role of coercion in this area, and to what extent that is a necessary component. I think you started to go to perhaps the commitments that the national intelligence community has to the community broadly when, for example, there are controversies, right, and laws in response to that. But I guess I'd just be curious to hear more on that.
So I do think that the book is in its broader sense about what law is about, in part by asking what intelligence is about. We ask what is the function of intelligence in world society, a question that the generalists by definition cannot ask because they're not looking to regulate intelligence as such. And so their analysis, the points of departure, lack the capacities to engage with such nuance. And so in asking what is intelligence functions are for, with all of its complex duality, with all of its moral ambiguity, predominantly around the kind of thing, be law breaking abroad, but law abiding at home, around, serve the interest of the polity, but also abuse other people's interests and rights in order to serve that interest. These are all profoundly difficult moral ambiguities that are hard to resolve. And then the question is where the law intersects with those kinds of debates. And so it is in that context that the core beef I have with generalists has to do with the limited viewpoint by which generalists see the world. Now, I'll just focus on one tiny example, and that's secrecy, because it was a topic that was running through the entire discussion today. This is something I like doing with my student. I do it all the time. So I have all kinds of tricks. So here's one of my tricks, okay? I go to my students, I ask my student, I'm going to tell you a secret right now. And I want you to react the same way you would react to hearing a secret, which is, I expect, in awe and shock. Here is a secret. You ready? Israel has nuclear weapons.
Sorry.
No, but where is the awe and shock? See, it is a secret. Israel has never publicly admitted that it has nuclear weapons. And yet, the secret is far well known. Getting to the point that the binary around secrecy is a misnomer. There are, as David Posen wrote in his famous Stanford Law Review article, deep secrets and shallow secrets. And the problem with, again, the generalist account around secrecy is that it moors itself to a binary that does not allow us to see the not so invisible conduct. The degrees, the layers of secrecy have to play a role in our understanding of what conduct is or is not involved in the iterative exchange. Now, some of it is regulated in international law. The ILC recently introduced the concept of particular custom, specific or local custom. This idea that a number of countries might know a secret that the others might not know, but because they operate around it and are able to engage in the iterative exchange around it, can generate a custom at least between them. What is that? It's a reflection that even within the codified general kind of formalist, positivist, Eurocentric law, there is a realization that there is more to just general custom, more ways to conceptualize the nuances of world affairs. And if we take particular custom to its root, then all kinds of secrets, when known to some degree, might play a role in the same iterative exchange, shaping a broader, more nuanced understanding of the law. That's what Sir Daniel Bethlehem wrote in his article, The Invisible World of International Law, where he says, you cannot ignore the invisible conduct because you're only telling half the story. And so this idea about what is law there to do, to me, right now, the binary is one between violation of sovereignty or not, ignoring myriad layers of toleration. What does the story of toleration to intrusions, to infractions, tell us about what is expected behavior? And if law is about expected behavior, not just some kind of a command with a sanction associated with, to use jurisprudential, keep forgetting, Austinian idea of what law is, a command with a sanction associated. No, it has to be a more complex story of what law is about. Law is about how societies and individuals interact day in and day out, what they tolerate and don't, what they understand to be applicable, acceptable or not in particular circumstances, where they can push the limits or not, jaywalking, crossing the street in red light. When are we saying that that is a violation of law? When are we saying that that is extension beyond the myth system? Not to embrace the operational code, not to embrace the law and the action in complete isolation from the myth, but to understand that the two dyads generate messiness, and law is messy, and that we cannot operate from the edges, from the purist perspective, but have to adopt some pragmatism. That's the essence of the way I view the world, and that's the New Haven School of International. You have like maybe one more thing.
Okay, so I have a question about applicability, right? And so as I was listening to y'all discuss like international spy law, which I know nothing at all, right? I thought about how is your book applicable to an area I do care about, which is labor and labor conflict and spy. It's like, right, an example, just really quick, the ground question is that, for example, McDonald's had hired ex-CIA operatives to engage in spying of the work that my employer at that time was doing, okay? And the law simply just says, no, thou shalt not. That's about it. My question to you is, how could you see your book kind of giving light to spying in private areas done by multinational corporations? Because I will say, even by way of example, that spying happened not just in the US, but also in a few other countries that I will stop naming.
Keep looking at me, so I'm guessing Canada.
But it's an applicability question.
So one thing the book does deal with in chapter 4 is upward delegation, sideways delegation, and downward delegation of the right to spy. And particularly in the downward delegation, I do spend a good chunk of that section dealing with privatization of the inherent governmental function of espionage. And I do ask predominantly about the relationship between states and its contractors, but commercial actors as well, who are involved in all sorts of ways, the complex nature of surveillance economy in all kinds of state activity around espionage. And how does predominantly international human rights law as evolved to shape, or in limited states to not address, the core question of privatization, which is the fundamental starting point of the analysis. So what I talk in the book about is that there's certain aspects that cannot be privatized, that the primordial scene is the privatization of a particular intelligence activity. But
Is that because of there's no justification for for
it's because
certain types of espionage?
it's because the notions of corporate actor not beholden to public interest, but beholden to the bottom line, will generate by design disproportionate and inefficacious.
Disproportionate, what was the last word?
And inefficacious, not effective. But you're asking a different question. Can a company engage in private means, not involving the actors of the state, former actors of the state, in carrying out espionage activities? The book does not, in its current form, address these kinds of business espionage activities, though they have become widespread. And in fact, one particular company that will never encourage you to go identify, Black Cube, it's called. Like, don't go on their website because it will download a cookie on your computer that you will never be able to run. Black Cube is all Mossad agents who are now sell their Mossad skills to private businesses to carry out precisely the kind of activities you ask. The idea is that a business like that, perhaps should never exist. The powers that we have granted the state to carry out these functions for very particularized reasons should not now exist in the private sector for private sector. That will be the challenge. But I'll stop there. We're at time and then don't want to take more of your time.
A million, thank you. Wonderful. And both of you, thank you again. Couldn't thank you enough.
Oh,
Obviously, it's the same conversation I had.
That's how I feel about the recording. So now-
That means.
Sorry,
let me give you one.
Question.
So like,